Looks like she's got a good record.
Starting off hitting the wrong buttons already. Good morning, everybody. Happy, what is it, Tuesday? Tuesday. Welcome to the Courtroom Files Live, where we're making mistakes early and often. Let's start the day with Judge McNally.
I was trying to get to a restroom, so
Okay.
in my defense.
To the charge impeding traffic, responsible or not responsible? Responsible or not? All right, I'm gonna accept your plea. $160 your total. You can go down the hall and take care of that. You're all set. Thank you. Do you have any more, Trooper?
Yeah, I have two more, Your Honor.
Are they scheduled for 9?
That is correct. At least that's what my email says.
Just let me double check this here.
Yes, sir.
Do you have any other information?
Don't.
The Lopez is ready, if you have that one.
Good morning, Mr. Teal. We're gonna find those for you. Give me 1 second.
I think you
Lopez.
just brought it in. Oh.
No, I know, but I want to get this trooper out of here. Lopez. And is there another one, Lisa?
Cabrera,
Cabrera.
that one needed an interpreter, so I'm not
Present, Your
sure if
Honor.
he's there in person.
Okay, great. Lopez and Cabrera. Is Lopez here? Lopez is on Zoom.
Here, I haven't checked the file since it's only 9 o'clock.
Yes, he's on Zoom, Mr. Lopez is.
Okay, so I'll take Lopez. Is Cabrera? Can you maybe interpret that for me? Just what's his first name? Cabrera, guys.
Luis Fernandez?
All right.
Is he on some too? Is he here?
Lopez is here. The interpreter for Cabrera is here. People against Elijah Trinidad Lopez. 25 B1485918. Your name, Mr. Lopez, you have to unmute.
I'm sorry, Your Honor.
Tell me your name, please.
Elijah Lopez. Elijah Trinidad Lopez.
Trooper, your name.
Daniel McLaughlin, Your Honor.
Did you check this gentleman's record?
The day of the traffic stop, I did, but I can't recall what it was. It's been just over a month and a half or so.
All right, so the charge here is invalid plate that he's going to informal on. Do you have a valid plate now?
Yes, Your Honor.
You have your registration with you?
I should. Yes.
Well, let me see it. Did he pay the no proof of insurance, Lisa?
Let me check. Yes, he did.
I'm sorry, Your Honor. It seems I don't have it in paper on me, but I do have
okay.
it on
Okay.
email.
Okay, I found him responsible on June 24th. What in the world's going on here? Or he was responsible by default. Why did this get rescheduled? Do you know, Lisa?
That's just the contempt hearing. He didn't pay it. Then he has 2 new cases today.
I see. I see. My mistake. So I've got Elijah Trinidad Lopez, 25M582029, A and B. I've got a limited access where he was written for 83 and a 70 and illegal window tint. So do you wish to offer? I mean, I can tell you he had a hazardous action. There was a crash in November of 22. Fair to stop, assured clear distance. It looks like there was a hazardous action in May of 24 out of this court, driving without due care and caution, and another violation for no proof insurance, which is this one. So he's charged with 83 and a 70 and defective equipment. So do you want to offer anything, Trooper?
I will be willing to reduce the 11 to 15 to 1 to 5 limited access. I did write him for a legal window tint because he had no prescription.
I can't hear you. I cannot hear you all of a sudden. Can you keep your voice up?
Can you hear me now, Your Honor?
Yeah, just stay close to that device.
Yes, sir. So
All right.
I will be willing to offer him 1 to 5 limited access. As far as the window tint, he's been advised get it removed and respectfully let the court make a decision. But if it hasn't been removed, then it'll be as is.
All right, so you can either plead this, you can either go to hearing on both of these, or you can plead the 75 and the 70 and illegal window tint.
Yes,
Mr.
Your
Lopez.
Honor.
What, do you want to do that? You want to plead the 75 and the 70 and illegal window tint with the understanding the 83 and the 70 will be dismissed?
Yes, Your Honor.
To the charge 75 and the 70, responsible or not responsible?
Responsible?
To the charge of illegal window tint, defective equipment, responsible or not responsible?
Responsible.
I'll accept those pleas. You better get that taken care of though, okay? Because if you don't, you're
Yes,
just
sir.
going to get ticketed again.
Of course.
All right, so I'm gonna charge you $170 on the speed. And on the defective equipment, I'm going to charge you. Can you pull that up? I'm gonna make it $140, okay? So you got 310, and you have a contempt charge we have to deal with on the invalid plate. Can you pay all this today?
I can maybe pay 200 as of right now. Well, I mean, I definitely can pay 200 right now. It's just I just
Slow down 1 second. Whose name is the bond in, Lisa?
No bond. It's just a contempt hearing for non-payment.
I'm sorry. Okay, I see. All right. All right. I'll tell you what, you're gonna pay the invalid plate today. That's 91A. So you're gonna either have to come up here or you're gonna have to put that online and then pay that online. And then the defective equipment, I'm gonna give you until October. Where do you work?
and on Montez Contracting.
You're gonna pay the defective equipment by October 3, that's 140, and you're going to pay the speeding by October the 17th. Can you do that?
Yes, sir.
All right, if you need more time, you call the court, we'll go on soon. Don't ignore us, all right? Best of luck to you. Thank you.
Thank you.
Where's that one? I want to get this interpreter out of here. If we have Cabrera here, is Cabrera here? I don't know if they'll understand what I'm saying, is the point. Can you just yell out if the Cabrera, what's the Cabrera gentleman?
That's just the Cabrera. Tío Cabrera?
Werner Moreno.
All right, I'm gonna have you, I'm gonna have to have you, sit down for a few minutes. I give them everybody 15 minutes, okay? So why don't you have a seat
I'm gonna
and
have a second case with you too,
which one's that?
Romero Chavez.
So Chavez
In custody, Monroe.
and Cabrera. Okay,
It's not till 10:30.
that's not till 10:30.
That's fine, I'll be here.
Trevine Deshaun Williams, 25F7213008.
Good morning, Your Honor. Kevin Battersby Whitnoff, P85532 on behalf of Mr. Williams.
Where is Mr. Williams? Is he on Zoom, Lisa?
He is. He's in the jail. I'm trying to move him out of the breakout room. There he is.
Sir, your name, please?
Trayvon Williams.
Good morning to you. So we're going to proceed to the exam on the 30th at 10:30. Anything
Thank
else, anything else, Mr. Whitnall?
A bond argument, if the court would entertain one, please.
Sure, get the prosecutor in here, John. Go ahead and start your argument. Mr. Wittenhoff, you can go in and start. Prosecutors controlled, right?
Thank you. Your Honor, there's
Mr.
an
Mohammed, your name?
Good morning, Your Honor. Mohammed on behalf of.
He wants to move to reduce set the bond on the 8th of 40,000, 10%. Go ahead.
Your Honor, there's an elephant in this bond argument, and I'm going to start by naming it. I'm going to be in complete candor with the court. Mr. Williams has a extradition warrant out of Ohio for a charge that I understand is labeled an aggravated homicide. Your Honor, that should have my bond argument dead in the water, but I think that deserves some context. Mr. Williams's charge out of Ohio is from an incident that happened in 2021. In 2022, they took his DNA in connection with that investigation. They cleared him and then ultimately charged him this month, September of 2025. This is a 4-year-old case, Your Honor. And Your Honor, I understand on its surface, it looks like Mr. Williams is not a candidate to have his bond reduced, but there's deeper meaning here, there's deeper issues. And Your Honor, I'm sure you think about that warrant out of Ohio, you're concerned about failure to appear. You're concerned about the fact that he's from Cincinnati, but he's not a typical out-of-stater. He has ties to this community, more ties to this community than some people who live in this community. He's been coming to the Metro Detroit area since he was 3 years old for family reunions, to visit family members. He has family on his maternal and his paternal sides living in this community. I spoke to members of his family on his maternal and his paternal side just yesterday. They offered help, they offered assistance. He has ties to this community. He will return to court if the court gives him the opportunity to get out on bond, because he knows this community. It's no different than him coming up for another family reunion, just coming up for this court date, Your Honor. Your Honor, I'm sure based on that warrant, you probably have some concerns about him being a danger to the community. Now, of course, we talked about the context surrounding that warrant in Ohio. But again, there's more to Mr. Williams than just one line on a law enforcement information network. Mr. Williams is a high school graduate. He's got a good job working construction for Ron Hall's Construction. He works that job to provide for his 2 children. Beyond that, Your Honor, Mr. Williams is a leader in his community. Unfortunately, I'm sad to share that Mr. Williams lost his best friend when he was 12 years old. He lost his best friend to suicide at that very, very young age. And now in his community, he's an advocate for mental health, especially amongst young men, making sure that young men don't ever find themselves in the situation that his best friend found themselves in. Your Honor, he's not a danger to the community. He's an asset to the community. He's got no connection with the alleged victim. When he was initially picked up here in Michigan, he had no idea why he was even in jail. He's got no assaultive history. And I'll remind this court that everything that is before this court, as well as what's going in Ohio, are just allegations. He's presumed to be innocent. And I know that this court knows that well. Your Honor, because he's got absolutely no connection to the alleged victim in this case, a no contact order in an exclusionary zone with any place that the complaining witness would go would be more than sufficient to ensure protection of that individual. He will return to court for the reasons that I stated, the community ties. He's not a threat to society. I'd ask that this court reduce the bond, currently 40,000, 10%. As this court well knows, Michigan Constitution entitles individuals to reasonable bond, and 40,000, 10% for somebody who's sitting in the courtroom with a tie on, that might seem like a reasonable bond, but for Mr. Williams, that's insurmountable.
All
I'd
right,
ask this
Mr.
court
Monk.
give him something that he can pay. Thank you.
Mr. Monk.
Your Honor, the people would object to reducing bond. We would actually request that the court increase bond to 50,000, half, no 10%. I do believe the defendant poses a serious danger to the public, not just based on the facts in this specific case, but his prior history, which includes a current pending warrant for 4 counts of felonious assault and aggravated murder. Additionally, there's another count of murder as well. So the defendant is facing multiple counts of murder. He's facing not 1 felonious assault charge, but 4. Additionally, I believe he poses a flight risk. He is a resident from Ohio, to my understanding, and that other pending murder case does stem out of Hamilton County in Ohio. So I believe that the defendant poses both a danger to the public and a flight risk. So we would respectfully object to reducing bond and motion the court to increase bond to 50,000 cash with no 10%. Thank you.
Very briefly, Mr. Whitnall.
Your Honor, no, thank you. The court's been gracious in the time it's given.
I'm adding 2 conditions. First of all, there's no contact with Demolius Buchanan. No contact with him or prosecution witnesses. You cannot go near 24953 Bay Fair and Flat Rock. No alcohol, no marijuana, no illegal drugs, no firearms, no dangerous weapons. So fitted with a GPS tether. That was not ordered previously, so that's a condition that I'm adding. And you're not to be within 2 miles of the victim, his residence or place of employment. 100,000, 10%. We'll see you next week. You're gonna have to post $10,000 with a tether. Good luck. Thank you very much. We'll see you guys next week at 10:30.
Thank you, Judge.
That's Johnny Von Hensley.
Good morning once again, everybody. Happy Tuesday. Welcome to the Courtroom Files Live, where I think I'm done pushing wrong buttons, but we'll see. Let's go to Miami-Dade. A whole different cast of characters this morning. This is Judge Thomas Rebel. The DA sounds like it's a different person. The public defender is different. Let's see what's going on.
All right, I'll set a monetary bond of $100. Oh, Mr. Ofeyasobi, I'm signing an order ordering you to stay away from the lifeguard tower at 13th Street on the beach. Do you understand that? Yes. Okay, thank you. Juan Castellanos Manrique.
They're getting him, Your Honor. 1 moment.
Thank you. Okay, Mr. Castellanos Manrique, you're charged with 1 count of trespass in an unoccupied structure or conveyance, which is a 2nd-degree misdemeanor. I've appointed the public defender. I'm also signing an order ordering you to have to stay away from the address at 959 Southwest 5th Street. You understand that?
Sure.
Okay.
Judge, we'd be asking for an ROR with the date certain. I don't see any local priors for Mr. Castellano. He told me he does not have an address right now where he can receive mail, but if he's given
but like I'm not living with my parents right now. But I can give you.
Actually, Your Honor, he does the permanent address listed on the A form. He says he can receive mail at that address. So we'd just be asking for an ROR. He doesn't need a date certain.
Okay. Mr. Castellanos Manrique, you received mail at that Windswept Drive, apartment
Yeah,
204?
I do before came to Miami, yes, sir.
Okay, all right. Okay, I will ROR him. I don't see any priors, any local. You have to stay away from that property where you were arrested. Do you understand that?
Yes, sir. But like, do you know like where is my stuff? Like because I had like my clothes and everything right there.
Yeah, you should talk to Miss Landrian or somebody else from the public defender's office. I'm not sure where it is. So,
Alright.
thanks. Felix Gonzalez.
Barbara, thank you for gifting 5 memberships. Very much appreciate that. And again, I hope you start feeling a little bit better today. Thank you so much.
The 075, he was adjudicated incompetent. So he cannot be held on that case, and we'd be asking for an ROR on this case.
I'm not sure what's the other case that you're referring to.
He does have another open case that I was able to run and found that he was previously adjudicated incompetent and ROR on that one. So we'd be asking for an ROR on this one as well.
But he just took a plea. I mean, I don't know if it's a plea, but he has a conviction CTS on August 29th, 2025. Like that's less than a month ago. So if he's incompetent, how could he have a conviction CTS of 2 days on coke possession on August 29th, 2025?
Which I don't see that one.
Is this Felix Jaime Gonzalez?
Yes.
Okay, I'm looking at the priors that the state provided me, and it was closed on 8/29/2025. F23 24203.
That's correct.
I'm not sure how he could be incompetent.
But yeah, I see that. I see what you're referring to. I do know that the case that is ending M245075 with a future hearing date of 10/21/2025. That case, he was previously adjudicated incompetent. He may have been restored in order to.
It's also possible that a
felony.
judge in, I guess it's possible that a judge in one case finds him incompetent, and another case says that he's not, that he
Yeah,
is
or he may
competent.
have been, incompetent at the time when the misdemeanor was open.
Right.
Nonetheless, we do think that for this case, he is currently homeless. We'd be asking for an RR with a date certain for him to come back on that date and get oral notice today.
We would be asked standard bond. This is a violation.
Okay. I'm gonna find probable cause. I'll set the bond on count 1 at $500 and count 2 at $250.
I'm sorry, Your Honor, I can't hear you. Can you please repeat that?
On count 1, $500, count 2, $250. Finding probable cause. Mr. Gonzalez, I'm signing an order for you to have no contact with the address at 2390 Northwest 2nd Avenue. You understand that? Mr. Gonzalez?
Yes.
Okay, thank you.
Well, that's a much more peaceful court with this guy. You got to say that. Speaking of peaceful, let's go say good morning to Judge Middleton. Haven't been there in a few days.
Good morning, Mr. Roberts.
Good morning, Mr. Middleton.
This is Judge Middleton again. Also with me is your lawyer, Jordan Harden, and Josh Robert from the prosecutor's office. He's the chief assistant. I arraigned you on this charge the other day. Let me remind you what it is. In this case, 251772, it's alleged on September 1st, you did assault, resist, oppose, or endanger Daniel Herman of the Sheriff's Department and Cody Middaw of the Sheriff's Department. That's 2 counts of resisting and obstructing a police officer. They also allege that you did maliciously destroy personal property worth more than $200 that belonged to Benny Staley. Thank you, Jordan. Actually, thank you, Jenny. That's a misdemeanor, but you're charged as being a 4th habitual offender, 3rd habitual offender, which would make those punishable by up to 4 years in prison. You also got charged and filed 251912 with malicious use of a telephone for allegedly making some threats to the church on Null Road. Ms. Harden represents you on that matter as well, and that's set for pretrial next Friday. We're going to address all of these. When I talked to you the other day, I had some concerns about how you were doing with your mental health. You've had some struggles. You've been through a lot of treatment at the VA. You've been to the forensic center in the past for an evaluation regarding competency, and you seem better today than you did that day. Ms. Harden has met with you at the jail, and she's asking that I set these matters for an evaluation as to competency, again, with the forensic center. Ms. Harden?
Thank you, Your Honor. I did meet with Mr. Roberts this morning. I did advise him of the pending charges, the one set for today, as well as the upcoming misdemeanor charge set for next week. For the court's record, the prosecutor has offered a misdemeanor resolution to the felony file. I did relay that to Mr. Roberts. Based on my conversations, I don't think he's interested in resolving it that way at this time.
Yes, I am. Yes,
okay.
I agree. That would be good with me.
You would be interested in entering a plea to a misdemeanor?
Yes, Your Honor.
All right, well, let's talk about that. Mr. Robert, what's the plea offer?
The offer is to plead to attempt R&O and an MDOP 200 to 1,000.
Well, regarding the case from September 18th, the prosecutor would dismiss the felony charges for a plea of 1 count to attempting to resist or obstruct a police officer. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. The malicious destruction on the truck would be over 200, but less than 1,000, which is also a misdemeanor, punishable by up to a year in jail and a fine of up to $1,000. That plea offer did not include the malicious use of a telephone?
No.
All right,
No, that was offered prior to the subsequent misdemeanor being
all right.
filed.
So that case, we could leave it. So, Mr. Roberts, I want to make sure that we're connecting. You've had a couple of days in jail since I saw you last. Have you been getting sleep?
Yes, Your Honor.
Have you been given any medication while you've been in custody?
Yes, Your Honor.
Are you on your medication now?
Yes, Your Honor.
And you would like to avail yourselves of that, yourself to that misdemeanor plea? That's correct?
Yes, Your Honor.
All right, well, let's talk a little bit about that. If you do plead to that misdemeanor charge, you're going to be giving up your right to have a trial in front of a judge or a jury. If you had a trial, you'd have the right to be represented by an attorney. Ms. Harden is representing you in both cases. You could also hire an attorney of your own choosing if you wished. For what it's worth, this applies to everybody else that's here, but I don't think we have any defendants here. If you had a trial, you'd have the right to take the witness stand and testify in your own behalf. But you don't have to, because you have a right not to testify, and if you did not wish to testify, the judge or jury cannot hold your silence against you, and you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. Do you understand?
Yes, I said think so. I'm not sure though, and I'm.
All right, well, do you remember what happened that day on September 18th?
Yeah, I was home all day. I documented everything on my Facebook that I was doing all day. And just trying to go through my rituals, my prayers and my meditation, what I do. Help me in my own yard, my own house. I documented everything I did all day on my Facebook page.
Your Honor, just for the record, this felony is stemming from an incident that is alleged to have occurred on September 1st.
September 1st, yes.
Yep.
Wilbur Road.
Oh,
wait a minute, I'm looking at the wrong. All right, did you get into it with your neighbor's truck?
No, Your Honor.
What they said is you were making some statements about being in Bronson County and you were going to shoot the schools and some of the same behavior you had done previously.
No, Your Honor. That previous stuff, that's when I was off my medicine. I was on drugs. I was drinking. That was like 3 years ago. But I was since.
Well, this was just in September. They allege that you got upset with this guy and yanked the door handle off his truck.
Well, he did, yes. He wanted me to take a look. I was looking at his truck. I thought I was going to buy a truck because it was for sale. I'm right next to my house. It had a for sale sign on it. I was just taking pictures, checking it out. And I did pull the door handle, then the door handle just fell off right in my hand. So I just give it to he came out and I gave it to him. I don't know, just door handle fell off. And I had his door handle. And that's when the police showed up and they saw me with the door handle.
Yeah, you still had the door handle when they took you to the hospital.
I don't believe I did. Maybe I did. I think I did. Maybe I did. If you say I did, I did. Then I guess.
But when they took him into custody, he still had the handle in his hands. And then they took you to the hospital and they gave you some orders that you failed to comply with. Do you remember that?
Yeah, I would uncomplied with any orders. I'd like to take that to trial, or I know the lady, she wants me to go to her church. She's a Baptist. She offered me to take me
Your Honor,
to church.
I think we're straying off of where we can
Yes.
proceed.
All right, who was that wanted you to go to her church?
The lady that owns the house, 2 houses from me. I forget her name. She has two sons that were with her. She's a real nice lady. She was there.
Well, we got okay on the surface, but the more we talk, the more I believe Ms. Harden's request for a competency evaluation is appropriate. The reason I was trying to build the ship and Bob here is this takes so long. If we do another competency evaluation, it's gonna be another set of several months before it can be resolved. But right now, I think you're still in the same agitated state you were at the time of these 2 incidents. There is a public safety issue because you've been making these random erratic threats.
What
But
threats? Robert's rules of order, point of order. Roberts is mistaken by his guilt. His guilt is from within that you cannot see, and I've done many things to point and inquire him the reciprocation of the event that happened. You're using dialect that's all visual, and there's no firm, concrete evidence that you have. Where is the victim? Who's the victim? What What number,
James,
what
I
label, what
hate to
address,
see it
where
like
did this come
this.
from? There's none of that in
This
there. It's
is-
hearsay. There's nothing.
All
there's no
right, this
physical
is
evidence at all.
active mental illness in our face. And I'm going to mute your microphone. And I'm going to refer both cases for competency evaluation. I thought we were doing better, Jim, but we're not there yet. So we're gonna get another evaluation. I can't take your plea if I don't believe you're competent to understand the nature of the proceedings against you and you're able to assist your lawyer. Right now, I don't think you can. So I'm gonna sign one competency order on the resisting obstructing and another one on the malicious use of the telephone. And you'll be evaluated at the forensic center. So Deputy Bulk, let's try Mr. Jude next, okay?
Your Honor, I will reach out to Pivotal at the jail.
I think they're aware of it, but
yeah, just to make sure if he's.
Lauren, the new jail liaison, she's been very helpful to me in several cases, and I'm happy to have her. We had Lisa all those years, and she's gone, and this new young lady, I think, is trying to be helpful.
All right, as Judge goes into the long history of jail liaisons, let's go back to Judge McNally.
So I have a waiver of trial by jury and election to be tried without jury. So Lisa, I'm going to need a bench trial date and a final pretrial date. Sir, you have the constitutional right to a jury trial. At a jury trial, 6 people would be impaneled. All 6 would have to agree beyond a reasonable doubt that you're guilty of the offense charged. By waiving your right to a jury trial, I will be the one who will solely decide your guilt or innocence. Do you understand that? Nice and loud for me.
Yes, sir.
And did you sign, read, and understand this document entitled waiver of trial by jury and election to be tried without jury?
Yes, sir.
Anybody force you to give up your right to a jury trial? All right, you still wish to do that, correct?
Yes.
All right, I'll accept the waiver. We'll set it for a final pretrial and a jury bench trial date. So maybe 2 weeks out on the 7th, and then maybe the
October 7th at 8:30 and October 14th at 1 o'clock.
okay, counsel, is that good?
I have a matter on 28th at 1 o'clock. On the 14th.
Are you on my
7. On your docket on the 33rd docket on the 7th.
Are you on the 14th too?
She was assigned to this case because there was a conflict with the court
I
appointed.
see. Okay, let's make the final, I'm sorry, October 7th, we're doing Lisa at 10 o'clock, did you say?
8:30.
8:30. And then let's see, how can we do the other one? Okay. Is that good, Lisa?
The 21st at 1 o'clock.
Yeah.
Okay.
21st at 1 o'clock will be your bench trial date. So October 7th, you have to be here for a final pretrial. That'll be at 8:30. And then on the 21st at 1 o'clock. Okay, sir?
Yes, sir.
So you're gonna go down the hall and get your notice. Do you have any questions?
No.
All right, thank you.
Thank you.
Thank you, Judge. Have a good day.
2, Hisham Nazi Hamoud, 25D815918. Morning, your name? Good morning. You're charged with a fish and game violation.
Yes.
Without a license. You have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer?
No, I think. The deal with this.
All right, let me arraign you and then I'll send you the prosecutor. Maybe they'll cut you a deal. You
Okay.
want to do that?
Yeah.
All right. On August 31 and 25 at 3:13 PM, it is alleged that you were on the Detroit River in Grosse Ile and that you did fish without a license. That's misdemeanor. Punishable by up to 100 fines, 90 days jail, costs, or all those. Do you understand that?
Yes.
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you will be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
All right, and you still wish to waive your right to a lawyer?
Yes.
not guilty pleas entered, a $100 personal bond. I'm just going to tell your bond conditions in case it doesn't resolve today. You cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. I'm not going to give you another date. You're going to go talk to the prosecutor. Either way, after you talk to the prosecutor, you'll come back in front of me, okay?
Okay.
So you can go out in the hallway and set up, he'll set you up. My court officer will, as soon as he returns, all right? You're welcome. Good luck. Jamal Ali Hamid, 25D815916. Morning, Mr. Hamid. You have to start your video, please. And unmute. There you go. Unmute now. Bottom left-hand corner. There you go.
Yes, sir. There. Thank you.
You're welcome. Your name?
My name is Jamal Hamid.
Good morning to you, Mr. Hammond. You're charged with a fishing without a license. You have the right to a lawyer if you want one. If you don't, I'm going to arraign you and I'm going to send you to the prosecutor and enter a not guilty plea and let you talk to the prosecutor. What do you want to do?
I don't need a lawyer, sir.
All right. I'm going to arraign you. It is alleged that on August 30 of 25 that you were fishing without a license on the Detroit River in Grosse Ile at 3:17 p.m. That is a misdemeanor punishable by up to 100 fines, 90 days jail, costs, or all those. Those are just the maximums. You understand that?
Yes, sir, I do.
All right. You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to a trial by court or jury. You have the right to question their own witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses, and the testifier remains silent. If you plead guilty, you're waiving the presumption of innocence, you're waiving all those rights, and you're waiving the requirement they prove you guilty beyond a reasonable doubt. Do you understand that?
Yes, sir.
So I'm gonna enter a guilty plea for you if you still wish to waive your right to a lawyer, and then I will send you over, to the prosecutor.
Thank you, sir.
$100 personal bond. You cannot leave the state without consent. You can't violate a law. You must appear in court as directed. So we're going to take this one to the prosecutor as well. Mohammed, why don't you take this one? John, why don't you give him the other one I just set down there? Okay. It was fishing without a license too. And you can call those guys in and take care of that for them, okay? You're handing that. All right, you're all set. Thank you very much, sir. Just wait right there. We'll put you in a breakout room with the prosecutor.
Can I get your name at the jail?
Jason Stacy.
Okay, be just a minute, okay?
Yes, Mr. Stacy's file, Mr. Mohammed?
Yes, I believe I can have it.
Okay. Mr. Grayson out here somewhere?
Mr. Howarth, do you need to talk to your client?
No, I don't. Thank you.
Thank you.
Okay.
You got the Grayson file?
I got the Grayson file.
I got to give it to the guy.
Okay.
He was 4 days.
Well, we'll be right with you guys. Right now. Okay.
It was. You want
All right. Jason Alexander David Stacy, 25R713-531. Good morning, Mr. Lakin. Your appearance?
Good morning, Your Honor. Mark Lakin for Mr. Stacy, P41147 for a continued PCC.
Sir, your name, please?
Jason Stacy.
So they just didn't complete the competency report yet, right? Is that what happened here?
Yes.
I'm asking you, Mr. Lakin, is that right?
Yeah, that is right. And we did get some sort of correspondence about a day after we were in court last time.
Wait a minute. Hang on a second. Who's so loud back there? Is that in the jail?
The jail. I muted them.
Jeez. Okay, go ahead. I'm sorry.
Your Honor, after the last delay and asked for, when we requested 30 more days, we did get some sort of correspondence from the forensic center that they were running behind. So I was hoping.
Yeah, I see. We're just going to adjourn it out for 30 days. Is that right?
Right. And hope Mr. Stacy's okay with that.
Okay. You understand that, Mr. Stacy? You don't understand that? We're awaiting the report, the competency report. So I'm going to adjourn this out so that the forensic examiner will send us a report by then. And I was going to put it out for 4 weeks. Do you understand that? Can you unmute him a second, Lisa?
I can't unmute him. He has to do it.
Okay. Do you understand everything I said, Mr. Stacy?
Yes, I do.
Okay, so we'll put this out 4 weeks. I guess that'd be what, the 21st, Lisa? At what time?
8:30.
Okay, Mr. Lakin, that's good with you, October 30 or October 21 at 8:30. You can appear on that one by Zoom if you want.
Appreciate that. Thank you.
All right, have a good day. We'll see you guys then. Thank you.
Thank you.
Marshbanks, Stephen Craig Marshbanks, 25F704575.
Good morning, Your Honor. James Howarth appearing on behalf of defendant Stephen Marchbanks.
Good morning, Mr. Howarth. Okay, there he is. He's on Zoom. Sir, you have to start your video and state your name, please.
Thanks.
Mr. Marchbanks.
Yes.
There you go. All right. Can you hear me, Mr. Marchbanks?
Yes,
All right, tell me your name, please.
my name is Stevie Marchbanks.
Okay, so what are we doing? We're just going to exam on this?
Yes, Your Honor.
And did you ever go over to Flat Rock and get printed?
No.
Why not? Judge Heston ordered you to do that. Why didn't you go there?
Oh, yeah, I got printed. Yeah, when they first took me in custody.
Okay, let me double check. Hang on. Wait a minute. I don't think so. I gotta double check.
They printed me when they took me in custody.
Right, he don't understand IT, so I'm gonna ask a question.
Okay, so whoever's talking back there, I'm gonna ask you to not do that, okay? You did not go over there, sir.
They when they took me in custody and came and got me from the Fed.
Listen, it's not on your lien. Judge Heston ordered you to go over and get printed on September 10th. And I expect you to go there today by noon. Do you understand me? Otherwise, I'm going to consider it to be a bond violation. I'm going to revoke your release and forfeit your bond. Do you understand that?
Yes, I'm finna go right now, Your Honor. Where do I go, Your Honor?
To the Flat Rock Police Department.
I'm going down there as soon as I get off the Zoom with you.
All right. So, counsel, we're going to go to exam, and this will be in person. It's going to be next Tuesday at 10:30 in the morning. And again, defendant to go to get printed today. Maybe you have to send that order over again to Flat Rock, Lisa.
Thank you.
Okay, so you make sure you go over there today. You understand that, right?
Yes, I'm on my way now. As soon as I get off Zoom with you.
All right, Mr. Howarth, anything else, sir?
No, Your Honor.
All right, we'll see you next week. Have a good day.
Thank you.
Thank you.
Thank you. Get the receipt. Get off here.
Yeah,
Still
he
on.
already exited you out of
No, it didn't.
All right, you're all set unless you have another one, Mr. Howarth.
Okie dokie, let's switch it up. 9 to 11% more Judge Boyd, now activated.
Oh, I'm doing okay. How are you doing?
Not so good.
Oh, well, I'm sorry to hear about that.
All right.
All right, so
We've been here a few times to propose a counter offer.
Mhm.
We were partially successful in proposing it. Without going into the details of the offer, Mr. Simmons can't accept it currently. He's asked for some additional time. He's from another state, so he has some questions about Texas law and how this applies to him. And I've discussed this with him prior studies, but he wants a more informative, thorough, more detailed discussion.
all right, so what I can tell you, Mr. Simmons, is that an offer was tendered to you July 29th. And so you came back on August 28th, so that was more than a month. Well, not exactly, I say a day shy of a month maybe. And then I reset it again for the 23rd, which is today. So today is the day. Either you've worked out an agreement with the state or you have not. If you have not worked out an agreement, then this is being set for jury trial. And the court will not consider any plea bargain agreements without good cause. Otherwise, you have to plead open to the court.
This is, can I speak now?
Yes.
What I'm saying is, well, my understanding of this was when I first gave me an offer, it was just throwing at me. But then the next offer, it wasn't off. It was I had offered today was something that I wasn't heard of to today.
Mhm.
The last two offers was jail time.
No. Here's the thing. I'm not allowed to hear what the offers were. This is what I can tell you. Sometimes offers will change because maybe the defense attorney may talk to the state, and then the state may see things a different way, and they may say, that first offer that I made really wasn't just. Defense has come to me and told me reasons why the offer should be something else. And then maybe they will agree with the defense attorney and offer that. So sometimes offer do change. Sometimes people will say, you know what? I'm going to take this to trial. And then maybe at trial, maybe the state doesn't have their witnesses, or maybe the offers change because they've had a chance to talk to the witnesses again. You just never know. What I'm telling you is today is your plea deadline date. And you've had over 60 days to think about whether or not you want a jury trial or not. So, counsel, are you available this afternoon?
Excluding the 1:30, the 175th doesn't have docket till 1:30. I'm set there for 2 people, but I'll be here this afternoon.
All right, so well, I tell you what, you have till 11 o'clock to let the court know. Is that good for you, counsel?
Perhaps afternoon would be best.
All right. So how long is it going to take you in the other court in the afternoon?
That I'm not certain, but I would hope to be here hopefully prior to 2:30.
All right. So you're going to need to be back here at 2 p.m. And you need to let the court know whether or not you've reached an agreement with the state. If you have not, then it's going to jury trial.
How could I negotiate about a cop out to something that I'm just hearing for the first time? Every time when I come to court, outside of court, I'm supposed to have contact with my public defenders discussing this case.
All right, so
I'm just hearing it every time I come to court. That's when I talk to my public defender.
all right.
Your Honor,
So it's like kind of shock and surprise to me. That's what I'm saying.
the offer that was made July 29th, I had explained to him that I was proposing a counter, that I explained what the counter was, what the counter would entail.
Mhm.
And I was successful in proposing that, except there's in the provision of the penal code that would authorize you to do something. There's not a number we could agree with. So we did make an offer that I explained to him. Unfortunately, it's just not an offer he could accept.
Okay. All right. So,
But I will speak with him after court right now.
okay.
And around at 2 o'clock, we'll get back here.
All right. 2 p.m. Thank you. All right. Is anyone else ready? No, that's at 1:30. 1:30. All right.
All right, let's head back to Michigan. Judge Middleton has a new contestant.
Judge, may I approach?
Certainly. You can approach, just don't get all the way here. All right, this is Kenneth Lee Hewitt. That's you, sir?
Yes, sir.
Mr. Hewitt, you're charged with possession of methamphetamine. Let's take a look at it. We get a lot of these also, unfortunately. It's alleged that on or about September 12th in the city of Sturgis, you did possess methamphetamine. That is a felony. It's punishable by up to 15 years in prison and a fine of up to 10 years in prison and a fine of up to $15,000. They allege that on that date, you got stopped in Sturgis And they found some residue and a small amount, 1.8 grams of methamphetamine. There's a lesser charge known as use of methamphetamine. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $2,000. Prosecutor has agreed to dismiss the felony charge for a plea to the misdemeanor charge of use. Do you understand?
Yes, sir.
Is that what you're going to do here?
Yes, sir.
I went through the advice of rights a minute ago with Mr. Roberts, maybe earlier. You've been here patiently all morning.
Yes, sir.
Do you understand you have those same rights?
Yes, sir.
You're giving those up by entering this plea?
Yes, sir.
Mr. Robert, you confirm the plea offer?
Yes, Your Honor.
All right, Mr. Hewitt, were you in a car, a Pontiac G6 on September 12th?
Yes, sir.
And at that time, had you used or possessed some methamphetamine?
Possessed, Judge.
Did you have some methamphetamine in your wallet?
Yes, sir.
All right, that'll be sufficient. Are you on probation or parole?
No. No.
What do you do, sir?
I'm retired.
What did you do before you retired?
Was a subcontractor. Independent contractor. I used to do like work for people, fix things, minor repairs.
Like construction kind of stuff? Okay. You don't have much in the way of a criminal history that I could see. Are you on probation or parole anywhere?
No, sir.
Have you ever been convicted of a drug charge like this in the past?
No.
Mr. Robert, do you have any objection to 7411 probation?
No, I'd leave that up to the court and to the defendant if that's something he's interested in.
There's a type of probation under the public health code known as 7411 because it's 333.7411. And it's a type of probation that would allow me to put you on probation. And if you successfully complete the probation, the charge could be taken off your record. There'd be no public record of conviction. Is that something that you'd be interested in?
Judge, I think he'd prefer to get it over with.
All right. All right. Are you related to Trevor Hewitt?
No, I am not.
I've spent quite a bit of time with him over the years in here.
I've heard of him.
Oh, he's always respectful to me and
Yeah.
he's awfully stubborn. Well, I'm not going to do the sentence then today. If I was going to do a 7411, I could put you in jail for about 90 days, which would be a lot worse than a probation. If I gave you a test today, would it be positive?
No, no, no.
For anything?
No, I don't drink or smoke weed or anything like that, pop pills or nothing.
All right. Do you have any money with you?
At this time, no. I get paid every second Wednesday of every month.
Well, I'd like to do a test at the day reporting center, but I don't have money to pay for it. If you're not presently using, there really isn't a need to put you on probation. I don't know how you came to have this in your wallet. I'm gonna set for sentence. Good morning, Mr. Jude. I'll be with you in just a minute. If I could find your lawyer.
Yeah.
Luke, are you blocked October 27th at 10:30? So, 10:30 a.m.
Yeah.
All right, I'm gonna get the police report. Look into some other stuff. Monday, October 27th. 10:30. Mr. O'Bear, if I could get a copy of the police report, any laboratory reports. Mr. Hewitt, put that on your refrigerator. You'll get probably a more formal notice, but I'll see you on October 27th at 10:30. All right, you're good to go. Thank you. No, I'll hold on to that one. All right. Thank you, Judge. Thank you. Mr. Jude, you got family here, your father and your brother. We're waiting for your lawyer.
Brother and nephew, sir.
Oh, brother and nephew. All right, yeah, it was your brother that was here at the hearing. She's here in the building, but she left me and go do something else. So stay with me for, what's that? Yeah, she's in Judge Patterson's court. You're looking good this morning. How are you feeling?
All right.
Good. All right. I'll see you in a minute. Now we're jammed up because I'll put you in the, we need the Zoom room for you, Mr. Bush, don't we?
Yes, sir.
All right, while he sorts out what he's going to do next, let's go back to Judge Dad.
Yes. I need Trooper Bayer and Mr. Swade. Trooper, your name?
Hi, good morning, Your Honor. Trooper Bayer, Michigan State Police.
Good morning, Mr. Swade, your name?
Hello, Mr. Eustace Wade.
All right. Is there any offer here, Trooper?
Yes, sir. I'm fine with amending it to a 1 to 5 limited access.
Do you want to do that, Mr. Swade? That would go on your record, but there's 0 points associated with that.
That's fine. The only thing I really wanted to say is, you know, driving that road.
Hey, you guys shut up.
What was that?
Go ahead.
That's it. That would work out. I appreciate it.
To the charge 75 and a 70, responsible or not responsible?
Responsible.
Okay, I'll accept your plea. All right, 160 is your total, okay? You can pay that today?
Yes, Your Honor.
All right, and I'm dismissing the 90 and a 70. You got to slow down, okay? It's pretty quick.
I completely understand that. The only thing I wanted to say is I'm in a Jeep Wrangler. That thing doesn't go over 85. And my buddy in front of me in the Mustang was going 90, he told me. So I don't know if the radar caught it. I'm sure the officer is doing his job correctly and all that, but my Wrangler doesn't go over 85. And I was going around a semi, and my buddy legit told me, he was like, I was going 90 and he didn't come and get me. And I was like, I mean, lucky for you, but I don't speed. Haven't had a ticket in a long time.
Okay, good luck to you. Good
I
luck.
appreciate it. Thank you.
Thank you.
You guys have a great one.
Bucarelli, Vincenzo James Bucarelli, 25M589868. Okay, Mr. Bucarelli, I'm gonna need this. There you go. Your name?
My name is Vincenzo Bucciarelli.
Good morning to you, Trooper. Your name again?
Yes, good morning, Trooper Buyer, Michigan State Police.
Any offer here?
Yes, Your Honor, 1 to 5 limited access is fine with me.
Do you want to plead the 75 and a 70, Mr. Bucarelli, with the understanding the 85 and a 70 will be dismissed? It's 0 points. It will go on your record, but it's 0 points.
Will this raise my insurance rate?
I don't, probably. Probably. I
That's-
don't know that, there's nothing I can do about that.
Well, I was hoping to fight this ticket so that I could,
You can fight the ticket if you want. If you want, I'll be glad to swear you to an oath and we can have a hearing on whether or not you were going 85 into 70. But if you do that, I want you to understand that you're going to have 2 points on your record if you lose.
okay. Yeah, I guess I'll fight it, Your Honor.
Okay, I just want to make sure that's what you want to do before I swear you in here.
Sure.
He's got you clocked at 85 into 70. I'm not saying he's right. I'm not saying he's wrong. I'm not saying you're right or wrong, but I just want you to be aware that that's what could happen if you fight the ticket. You take the 75 and a 70, that's 0 points still. It's up to you.
If it increases my insurance rate, that's gonna cause financial hardship on my family.
Look, it's going to be worse though. Sometimes you got to cut your losses. I'm not trying to encourage you to take the deal or not take the deal. But if you don't think if you can't testify truthfully that you were going 75 or less, you're going to end up in a worse position. Okay? Nobody's trying, I mean, I don't know what else to tell you. Where's Hussein Bazi? Is he here? Hussein Ali Bazi? Let me go on to that and you think about it, Mr. Bucarelli, okay?
Okay.
Hussein Bazi, this is People Against Hussein Ali Bazi, file 25M589907. Mr. Bazi, where are you? There you are.
Good morning, Your Honor.
Your name,
morning.
sir?
Hussein Bazi.
All right, so Trooper, your name again.
Yes, good morning, Trooper Buyer, Michigan State Police.
All right, I don't think I mean, geez, his record, have you seen his record?
I have. He's got 7 prior speeds, to my understanding.
I mean, you got to slow down and he's got you going 95. What do you want to do on this one, Trooper?
I'm fine with amending it, but 6 to 10 limited access probably be the best I'd go.
You want to plead the 10 over, sir, 6 to 10 limited access, which is 1 point, or do you want to fight the ticket on a 95 and a 70?
Your Honor, I mean, I'm not trying to fight the ticket. I explained that.
Okay, so here's your choices. I got a lot of people. I got a big docket. I'm not trying to, I just want to know if you want to plead the 6 to 10 over, or if you want a hearing on 95 and a 70. You just tell me what you want to do. I don't need to hear any explanations or anything else.
Okay.
You got to stop driving like a maniac, with all due respect.
Totally understandable, Your Honor.
What do you want to do?
Am I able to speak to the officer in the breakout room?
I don't think he's going to do better, and he just did. Come on, if you got to tell me if you're doing 6 to 10 over, or if you want to have a hearing on 95 and a 70. Come on, one way or the other.
Your Honor.
6 to 10 over.
Yes, Your Honor.
To the charge, 6 to 10 over, limited access. Responsible or not responsible?
Responsible, Your Honor.
Plea is accepted. You got to slow down. You're gonna hurt yourself or somebody else. $200. Can you pay that today?
Yes, Your Honor.
All right, good luck to you.
Thank you.
$200. Have a good day. Thank you.
Thank you.
Please slow down.
Will do.
All right. John. All right, recalling Bucarelli. Vincenzo James Bucarelli, 25M589868. Your name again, Mr. Bucarelli?
Vincenzo Bucciarelli.
All right, Trooper, your name again?
Yes, Your Honor. Trooper Buyer, Michigan State Police.
So he's still gonna offer you 5 over limited access, or you can go to the hearing. It's up to you, sir. I'd need a yes or no. Come on, I mean,
Yeah, I'll take it.
to the charge, 75 and a 70, limited access, 1 to 5 over, responsible or not responsible?
Responsible.
I'll accept the plea, $175. The original charge is dismissed. Okay, good luck. You can pay that now, right?
Yes.
Okay, good luck. People against Carmody. Jessica Nicole Carmody, 25T645-743. Where's Miss Carmody? Your name, ma'am?
Jessica Carmody.
All right. You're here for a contempt hearing. Can you pay this amount, ma'am?
Not today.
Well, you've had since May. You got to start to pay on this. You haven't paid a nickel. Where do you work? How much do you make?
I just went back to work, September. I work for the Lincoln Park School District.
What do you do there?
I'm a paraprofessional for children.
You got
with
paid all summer though, too, right?
No, my contract is not because I'm not a teacher.
Okay. Tell me how much you can pay, ma'am.
I can have it all paid off by the end of October.
Well, I don't want to do that. We're going to set up a weekly plan here. Okay. So you tell me how much you can pay per week.
Could we do bi-weekly when I get paid?
I don't care. Just tell me when you can pay this.
What is the total?
You have 282 on the fine and you have a $45 clearance fee.
Okay, so the second I could pay half of it.
All right.
And then on the 16th, I could have it.
Wait, defendant to pay 140 by October 2nd. Balance by October 16th. Is that fair?
Yep.
And remember, you have to pay your clearance fee because on a no proof of insurance, you are in suspension right now. You cannot drive until you pay that ticket off. You understand?
Yes.
And pay your clearance fee. And then you have to check your record. I didn't look at your record to make sure you're otherwise eligible, but you're definitely not eligible to drive now. Okay?
Okay.
Good luck. Wish you well. Any questions?
Nope.
Maria Yesenia Roblero, 25M588734. Is she here? Defendant failed to appear. She's responsible as charged by default. Let's take DeAndre Bernard Mankin, 25T721756. Is Mr. Mankin here? Mr. Cooper, your appearance? Good
Yes,
morning.
Renee Cooper for Mr. Madkin. Good morning. My understanding is that he was picked up by another jurisdiction, and Mr. Mohammed, I think, has notes on the file indicating that we'd like a 1-week adjournment, since apparently no one knew about this until yesterday.
I understand. So, Lisa, I'm going to try to read this. Family, it looks like contacted again to verify that we notified Macomb Jail, advised that I've searched multiple times and cannot locate defendant. Family states he's being released on September 25th. Is
That's
that
correct. And then this morning I got a notice from Wayne County Jail that they have a detainer. So they expect to pick him back up this week. So I'm hoping next week he'll be at Wayne County.
all right? So we're gonna adjourn the PCC to September 30 and the exam to the 7th. Okay, Mr. Cooper?
Yes, that's fine, Judge. Yes, thank you.
So September 30 at 9 o'clock, and then and October 7th at what time are we gonna do, Lisa? 10:45?
10:45.
Okay. So
Okay.
you're all set. So October 7th at 10:45, next week, the 30th at 9 a.m. All right?
All right. See you then, Judge. Take
Have a
care.
good day. Thank you.
All right, let's go back to Judge Middleton's court. It looks like that guy's lawyer has finally come in.
For your patience. Your lawyer, Rhonda Ives, is here. Your brother is here, and your nephew is here. And this is the time and date we're going to deal with your case. Can you hear me okay?
Yeah, I hear you.
All right, you got charged way back in May of 2024 with home invasion, 3rd degree, which is a felony punishable by up to 5 years in prison, and malicious destruction of personal property over 200 but less than 1,000. That's a misdemeanor punishable by up to a year in jail and a fine of up to $1,000 or 3 times the value of the property. Prosecutor Robert has agreed to reduce the home invasion charge to a misdemeanor known as illegal entry. Illegal entry is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Essentially, it means going into somebody's property without permission. It's not a breaking and entering or a home invasion. Malicious destruction of property has to do with this broken window. That's a misdemeanor punishable by up to a year in jail and a fine of up to $1,000, as I said. Your lawyer, Ms. Ives, indicated that you're willing to plead no contest to that charge and bring this matter to a close. Is that correct?
Yeah.
By pleading no contest, you don't admit what happened, but you also don't deny what happened, and you would allow or accept that a conviction would enter. Do you understand?
Yeah.
I'll use the bond information form to form the factual basis. Do you understand that by pleading no contest, you give up your right to have a trial in front of a judge or jury? There will be no trial. Do you understand that?
Yeah.
If you had a trial, you'd have the right to be represented by an attorney. Ms. Ives has been here with you from the start. She's here with you today. Could also hire an attorney of your own choosing if you wished. Yeah. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. Anybody threaten you to get you to plead to these charges?
No.
Or promise you anything other than this plea agreement that I related?
No.
All right, well, let's take a look at the bond sheet here. I do remember this. It happened last spring at your father's house, Hiawatha Drive. You were agitated that day, and at about 10 o'clock at night, no, 8:30 at night, you were spray painting the front door with the words "keep out." There was also a window broken. The neighbor called and advised she heard the glass breaking and subject yelling. She looked outside. She saw James standing in front of the broken window. He had a personal protection order. You were living on a camper on the property, but you weren't supposed to go into the house. They were in the residence earlier in the day and the window wasn't broken. The doors weren't spray painted. you'd gone into the house and left your cell phone inside the house, so you went in there without their permission. The window was approximately $400 to $800 to replace. They also had a personal protection order against you. So there is a factual basis for the illegal entry. Illegal entry, as I indicated, is punishable by up to 93 days in jail. You've been in jail for 496 days, mostly because you wouldn't talk to anybody. I'm going to give you 496 days, credit 496 days. Even if I wanted to give you more jail, I don't have the authority to do it. The time you've served exceeds the amount. Theoretically, the time at the forensic center tolls any delay issues in the case, but you do get credit for that. And I can't sentence you to exceed the statutory maximum. That's going to be concurrent with the MDOP charge. We've never received any input from your family about restitution or the amount due. So I'm not going to deal with that. The MDOP charge, I didn't ask for any elocution because there really isn't anything to say. I can't do anything more than this. 496 days credit, 496 days on the MDOP over 200. 100,000 concurrent with illegal entry. And there's a $125 fine, which is the minimum allowable fine. I'm going to give you until December 1st to pay it. I'm going to give you that envelope with this fine in it. Give that to his brother. What's your plan for when you get out, Mr. Jude?
Stay with my brother and get a job. Get a job.
All right, that sounds like a good plan. He lives in Dowagiac?
Yeah.
He's here in the courtroom, Your Honor.
Yes, he's been here. He was at the competency hearing also. Are you taking your medication?
Yeah.
All right. It was interesting. The forensic center said you were cooperative, respectful to the other people there. You just wouldn't talk to the treatment providers or your lawyer. And so that took 496 days to get through this. But this resolves it. You're going to get out of jail today. Your brother's going to stop at the jail and pick you up. I don't know if the PPO that your parents had is still in effect. But my advice is you do not have contact with them. I did not order any restitution. If they're interested in it, they can file a civil action in small claims court or try to work something out with you. 24803 FI. There's really nothing more I can do here. You've always been respectful to me. You just wouldn't talk to me. We got through what we needed to do today. Mr. Jude, I wish you luck over in Cass County. Your brother's going to come pick you up probably within the next hour. Take a little bit to book you out. Do you have any questions?
No.
All right. You're good to go. We got yep and no, but it was enough to get us through what we needed to do.
All right, well, he moves on to the next contestant there. Let's go to Louisiana, where it looks like a couple of the board members are actually appearing remotely today, which is a little different.
Parole is called to order. Today's date is September the 23rd, 2025. The time is 9:03. My name is Carolyn Stapleton. I'll be serving as chairman today. My colleagues on today's panel are Ms. Ledoux, Ms. Jerry Ledoux, and Mr. Steve Prater. The panel today is at, well, do I say the panel today is at DOC headquarters in Baton Rouge, Louisiana? Headquarters staff, please introduce yourself for the record.
Jasmine.
Jalen.
Sherelle. Carla Williams. Okay. Mr. Brumfield, you are housed at St. Charles Parish Jail with the staff at that location. Please introduce yourself. Do you have anybody in the room with you?
Yes, Lieutenant Kimberly Ball.
Okay. All right. Mr. Brumfield, for the record, would you please introduce yourself with your full name and state your DOC number?
Tony Brumfield. My DOC number is 478003.
Okay. Do you have a questionnaire in front of you that you filled out?
Yes, I do.
Yes, you do. Okay. According to this questionnaire, you're not eligible for appointed counsel. You understand that, correct?
I understand.
Okay. And you do not have counsel with you today?
I don't.
Okay. I will read aloud. Well, your case has been assigned to Ms. Ledoux. I will have Ms. Ledoux read aloud your rule violations, and then she will get your responses, and we'll go from there. Ms. Ledoux, are you ready?
Mr. Brumfield, you've been charged with violating conditions number 4, 5, and 10 of your parole. I'm going to read those, and I need a plea of guilty, not guilty, or guilty with a statement. On rule number 4, it's alleged that you violated this condition when you were arrested on 9/2/22 by Harahan Police and charged with the intent to produce, manufacture, and distribute. I'll read all of these. Cocaine, coca leaves, or derivatives. 4 counts of intent to produce, manufacture, or distribute amphetamines. Intent to distribute, produce, manufacture, or distribute oxycodone. Possession of Schedule 1. Possession of marijuana. Possession with the intent to distribute clonazepam. Illegal carrying of a weapon. Possession of a firearm with an obliterated number. And illegal possession of a stolen firearm. These charges have been taken up by the federal court, and you are currently in the custody of the U.S. Marshals. How do you plead on that?
I would like to plead not guilty.
On allegation of number 5, it's alleged that you violated your condition when arrested and charged with the illegal carrying of a weapon, possession of a firearm with obliterated numbers of marks, and illegal possession of a stolen firearm. How do you plead?
Also not guilty.
Okay. And number 10, it's alleged that you have failed to provide proof of payments since you were put on supervision. How do you plead to that?
That one will be guilty with a statement.
Okay, I'll entertain that statement at this time.
Okay, I was in constant communication with my parole officer. Her name was Heather Pennington. I came home, I got a job, got another job, an even better job. I began driving trucks. I just started taking care of some of the most important things first, like getting a car and getting a place to stay. Unfortunately, shortly after, I lost my job because of an occurrence with my eyes. My eyesight got bad. I couldn't drive trucks for a while, and I just started taking side jobs in the process. But I was in constant communication with my parole officer, and I told her as soon as I got steady income, I would begin to, chip away at those payments. Unfortunately, this occurred. The incident with the drugs and whatnot occurred before that could ever take place.
Okay, so that doesn't change the fact that you're $2,142 in arrears, right?
That's right.
Okay.
It doesn't.
So, Mr. Brumfield, you're a 6th felony offender. So being on supervision, how many times have you actually been on supervision?
I, it's as sad as it is to say, I've lost count. I don't know.
Okay, and has a trial date been set for this matter?
There has not been one. There's certain things that we're currently still trying to litigate. That's some of the things I actually wanted to discuss today.
Well, the charges are currently pending. After the preliminary hearing, there was ample evidence to make a decision that you were in violation of your parole. Speak on your behalf in that matter.
Okay, I would just like to first say, exactly what happened, and then I'll tell you how we plan to prove that over here in the courtroom. That day, I borrowed my son's vehicle. I was stopped by Harahan police while leaving the hospital that night. They found a book sack in the rear of the vehicle. That's where all the things that they found were. Once I provided them with the insurance to the vehicle, which had my son's address on it, they went to that house and they searched that house. That's where the weapons were found. There was not a weapon in the car or a weapon on me. I never possessed a weapon. My son was at that house. They charged my son. My son was 19 at the time. He's pled guilty and actually served time for these charges. How I plan to prove it? There's video footage of me taking a lift to my son's house that day, borrowing his car, showing that I stopped shortly after. There's also proof that I didn't live there. There's also camera footage in my neighborhood where I actually live, showing that I left my house that day, that I live there, that I received mail there. I have a room there, that I didn't live at the house where things were found. That's my son's house. He's accepted responsibility. There's also an affidavit from him stating everything that I'm stating here. And this is actually how I plan to prove this in the courtroom as well.
I should make note that you were under surveillance already by the marshals.
Yes.
So there's reason to believe that you were involved in illegal conduct, and it's very common that people have one address, all their stuff's at that address, they
That's
get
correct.
mail at that address, but their head is laid down at another place every night.
That's why I say I plan to provide the video footage of my own to show that
Yeah.
that wasn't the case.
Yeah, I don't have that video evidence, and the evidence that I've been presented gives me cause to believe that that you have violated your conditions. Would my colleagues have any questions of this offender?
No.
I don't have any.
Okay. Is there anyone speaking? I don't know who his visitors, or does he have anyone?
He doesn't have.
Okay. I have the arrest report. And I have all of your notes from the parole supervision. Mr. Brumfield, at this time, my vote is going to be to revoke your parole based on the preponderance of evidence that you violated the conditions of your supervision.
Mr. Prater?
I concur. Same reasons.
And I concur also for the same reasons. So finally, in conclusion, Mr. Brumfield, today your parole has been revoked. And this concludes our business.
Denied.
And there's our standard, fairly standard anyways, result that we see from our friends in Louisiana. let's go back to Judge Middleton, where his parade of different shades of stripes continues.
Middleton, I'm here with your lawyer, Mr. John Bush, and Chief Assistant Prosecuting Attorney Joshua Robert. You got two cases. One is set for today. No, they're both set for today. One is file 251777FY. That alleges carrying concealed weapon, possession of a taser, and domestic violence. The first two are felonies. Carrying concealed weapon is punishable by up to 5 years in prison. Prosecutor Robert has offered to dismiss both of those charges for a plea to domestic violence, and that would be on your spouse, Stine Krogostad. I think that's a Swedish name.
It's Norwegian.
Norwegian. The other case is from a year ago, August 30th. That alleges domestic violence on your mother. And that is file number 241606, and your mother is Kathleen Corzine. So the plea offer is to dismiss the felony charges, plead to one count of domestic violence from August 30th of 2024. Domestic violence is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. And one count of domestic violence from September 5th of 2025. So it'd be two misdemeanor domestic violence. The felony cases would be dismissed. Mr. O'Bear, is that your understanding?
Yes, it is.
Mr. Bush?
That is also my understanding. Yeah.
Mr. Wright, are you going to plead to two misdemeanor counts of domestic violence?
Yes, sir.
Very good. All right, let's talk about that for a minute. If you plead guilty to these charges, you're going to be giving up your right to have a trial. You'd have a right to have a trial in both cases or either case. You settled one and wanted to try the other one. If you had a trial, you'd have the right to be represented by an attorney. Mr. Bush has been appointed to represent you. You could also hire an attorney of your own choosing if you wish. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to, because you have a right not to testify. And if you did not wish to testify, the judge or jury cannot hold your silence against you, and you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. On 606. All right. Anybody threaten you to get you to plead to these charges?
No, sir.
Promise you anything?
No, sir.
Well, let's talk about the first one. And that case is alleged that on August 30th of 2024, which would have been last summer, you made an assault upon your mother, Kathleen Corazini, in Three Rivers. This would have been, I think, at the house on Oklahoma Drive. Does that sound right?
Yes, sir.
All right. Did you get upset with your mother that day?
Yes, sir.
And did you grab her by the arms and push her?
Allegedly, yes.
All right, at some point, grabbed her by the throat. All right.
I don't know if that's a factual basis. He said allegedly, yes. He
Oh,
didn't
all right,
admit to
yeah,
doing
all right,
anything.
let's find out. Did you, says here, you grabbed her by the arms, grabbed her by the throat, pushed her and scared her while you were yelling at her. Did that happen?
Yes, sir.
All right, that's a factual basis. Let's talk about the other case. This one's a little more recent in time. Again, this is at the Oklahoma Drive address.
Yes, sir.
And you're married to your spouse who is Stine. Is it Stine or Stein?
It's Stina Krogstad.
All right, that's your wife.
Yes, sir.
And did you get upset with her
Yes, sir.
and grabbed her by the face?
Yes, sir.
And she wanted a divorce and you didn't.
Correct.
Is that true? All right.
Yes, sir.
I'm gonna need more information here.
Judge, I would ask for a PSI in this one. He has a out-of-state criminal history that's hard to decipher. Would be helpful to get all that information from one of the
All right.
probation agents.
I did a PPO in this case, so I have some familiarity with it. They were quite frightened. There was a meth pipe in here, so I think meth was underlying this. You seem good this morning, clear-headed, smart. I think you've had some clean time, thanks to Judge Pattison, which is a good thing. All right, I'm gonna ask for a PSI, which is called a pre-sentence investigation. It's gonna take a little bit to do that. Are you on probation or parole anywhere?
No, sir.
What kind of work did you do?
I was a handyman for a while. I've been on and off the streets, like you said. I've had an addiction problem that I'm trying to address now.
All right, well, sometimes going to jail is where you started.
I agree.
Do you and she have children together?
Yes, we have 3 little ones.
Well, at some point I understood she was talking about going back to Norway. Is that in the mix?
I don't know. Like I said, I haven't been able to talk to either. I'm in the dark with everything, so.
All right.
I hope not. I hope to reconcile all this and get the help I need. This is the first time I've actually addressed it in my life, so.
All right. Well, we're off to a forced sobriety, which is a place to start. This is gonna take me a while. So let's go to that October 20th date, John. At 10:30. It's gonna take me about a month to get this pre-sentence investigation report done. Judge Pattison canceled your bond because he was concerned about public safety issues. This will be just a way to get you some additional clean time and keep everybody safe. The worst that could happen here is you could get 93 days followed by 93 days. That's not probably likely to happen. But I need more information. I'm gonna set for sentence for 10/20/25 at 10:30.
Do I have a
All
moment?
right, Mr. Wright. Are you doing any classes or anything at the jail?
Yeah, I just did Endeavo for domestic violence. I just got a certificate. I guess Pivotal has to print them out, so I'm waiting to hear from her.
Very good. You take whatever they got and see you on the 20th. All right, that's
thank you.
all right. All right, we'll get a pre-sentence report. We'll get input from the victims. And he's gonna be right where he is for a while.
All right, let's rotate back down to Judge Boyd.
All right, court is calling 2025 CR 008466, State versus Miguel Angel Ramirez Galvan. Can I have parties announced for the record?
Megan Galloway for the state.
Alfonso Otero for Mr. Galvan.
And are you Mr. Galvan?
Yes.
All right, we have an interpreter here. If you could raise your right hand. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
Yes, John.
All right, you may lower your hand if you'll state your name for the record.
Yes. Jacqueline Payan.
All right. Mr. Galvan, all of the records that I'm going to review with you are in English. Were those explained to you in Spanish?
Yes.
Yes.
All right, so I know that in Spanish, the little Spanish I do know, I know that yes is in English, and I know in Spanish it's sí. Am I incorrect?
Correct.
So either we're going to use the interpreter or we're not going to use the interpreter. Do you understand?
Yes.
Okay. Counsel, do you speak Spanish?
I do, Judge.
And do you speak it fluently?
I do, Judge.
And were you able to explain these documents to your client in Spanish?
I will, Judge.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Are there any applications in this case?
No, Judge.
Mr. Galvan, have you reviewed the true bill of indictment with your attorney?
Yes.
Did you understand it?
Yes.
All right, so you're gonna have to wait till the interpreter interprets before you answer. Understand?
Yes.
All right, counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor, the state moves to proceed on the lesser included offense of possession of a controlled substance, PG 1 less than 1 gram.
Any objection?
No, Judge.
Yes.
Did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Court is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial. a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Galvan, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Did you understand if you're not a US citizen, by entering into this plea, you could be deported, denied naturalization, and denied re-entry into the United States?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1, less than 1 gram. They're asking that your punishment be assessed at an $800 fine, 149 days in the Bexar County Jail under 1244, taking consideration 2025 PF 16342. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Judge.
Then how do you plead to the less included offense of possession of a controlled substance, penalty group 1, less than 1 gram?
Guilty.
State, any evidence?
State offers states 1 on attachments.
No objection, Judge.
State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering into this plea, the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, Judge. Just reversion.
All right, as previously stated, the court will find you guilty. The court will sentence you to 149 days in the Bexar County Jail under 1244. There's an $800 fine. Time and money will run concurrently. Taking consideration 2025 PF 16342, and the court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. If you're using drugs, only 1 or 2 things going to end up happening. Either you're going to end up in and out of somebody's jail or prison, or either the last time you use is going to be the last time you use, and somebody will have to identify your body. So if you have an issue with drug addiction, You come back to court, I'm still here. I'll pick up the phone and find a place that can help you, okay? All right, good luck to you.
Okie dokie, before we go to the next court, Barbara just asked in the chat, can you make some videos with Judge Fleischer for us, please? Maybe someday. I have a bunch of Judge Fleischer material, but this is all material that I've already sorted through and pulled out the best back when we were making standalone Judge Fleischer videos. So we'd kind of have to go to B-tier cases, but we may scrub through that and try to find some more things at some point. We all miss him, Barbara. Wish he'd come back. I don't think he ever will. Some people disagree with me, but time will tell. Let's go back to Judge Middleton. He has another orange contestant.
Good afternoon or good morning, sir. Are you Ricky Wendell Murphy?
Yes, sir.
All right, Laura, I'd still like a bind over waiver sheet on Mr. Murphy. This is Judge Middleton. I don't think we met before. You're from Edwardsburg?
Yes, I am.
Well, you got charged with operating a motor vehicle while intoxicated as a third offense.
Correct.
Let's take a look at that. Also with reckless driving and driving suspended.
Yeah, I wasn't suspended.
All right, well, that's a misdemeanor. That's just sort of on there.
Yeah, for sure.
These things allegedly occurred here in St. Joseph County on August 31st.
Correct.
Well, let me find it. It's alleged that on August 31st in the city of Three Rivers, you did operate a vehicle upon Millard Street with a high blood alcohol level over 0.17 and as a third or subsequent offense. Under Michigan law, that is a felony. Looks like you got several convictions in Indiana. That is a felony punishable by up to $5,000 and up to 5 years in prison. Carries 6 points on your driver's license and requires that your license be suspended. Reckless driving is a allegation that you were driving on 131 southbound in the northbound lanes. We sure have had a lot of that lately. And that's a 93-day misdemeanor. And you're also charged with driving suspended. You're entitled to have a preliminary examination in that matter. You're also entitled to waive it and have the matter bound over to the circuit court for further proceedings in that court. Mr. Bush indicated that at this point you wish to waive the preliminary examination, have the matter bound over to circuit court and deal with it up there. Is that correct?
Yes, sir.
Mr. Murphy, your blood alcohol level, I received it this morning, and you were tested at the State Police Crime Lab of 0.212. So that's consistent with the police report. So it's my recommendation that we execute the waiver and move the case forward.
Yes.
All right, let me read that to you. I, Ricky Wendell Murphy, understand I have a right to employ an attorney. I may request a court-appointed attorney if I'm financially unable to employ one. I voluntarily waive my right to a preliminary examination and understand that I will be bound over to the circuit court on the charges in the complaint and warrant. Is that what you wish to do?
Yes.
All right, I'll put defendant waives on the record. I lost my bailiff. John, let me give you that and ask if you and Josh could please execute that. All right, Mr. Murphy, the matter will be bound over to the circuit court for a status conference, hopefully sooner rather than later, and see whether it can be resolved. Are you on probation or parole anywhere?
No, sir.
We'll probably be setting this a plea as soon as
All right,
possible.
well, it may be something we could consider for sobriety court. We'll cross that bridge when we get to it. All right, good luck, sir. I may be seeing you further.
Thank you, Mr. Murphy.
Okay.
All right, I'm sure we'll come back when he gets another contestant. Let's go back to Judge Boyd, who has somebody approaching.
Court today's around here somewhere. He's doing good.
Okay.
Thank you for asking. I let him know you asked him.
I keep telling him he needs to write his memoirs. His story is so fascinating. I had a chance to have, we were at an event and I had lunch and dinner with him. He was telling us all about the Miss America pageant and everything.
Good luck, man, for sure.
Yeah. All right, the court is calling 2025 CR 008-730, State versus Marlon Vasquez. Can I have parties announced?
Lauren Espinoza for the state.
Eddie Garcia for Mr. Vasquez, Your Honor.
And are you Marlon Vasquez?
Yes.
All right, so we have an interpreter here. If you could raise your right hand again. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Jacqueline Faya.
All right, Mr. Vasquez, all of the documents I'm going to review with you are in English. Were those documents explained to you in Spanish?
Yes.
All right, and counsel, do you speak Spanish?
I do, Your Honor.
And do you speak it fluently?
I do.
And were you able to explain these documents to your client in Spanish?
Was.
And counsel, have you received all discovery and did you review with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Vasquez, did you review the true bill of indictment with your attorney? Did you understand it?
Yeah.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right, Mr. Vasquez, did you review the court admonishments with your attorney? Did you understand it?
Yes.
All right. You're charged with the offense of possession of a controlled substance, penalty group 2, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Vasquez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
No.
Anyone promise you anything other than the plea?
No.
No.
Are you satisfied with the way you've been represented?
Yes.
Did you understand by entering into this plea bargain agreement, if you're not a citizen of the United States, you can be deported, denied naturalization, and denied re-entry into the country? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at $1,000 fine, 138 days in the Bexar County Jail under 1244. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Then how do you plead to the offenses charged?
Guilty.
State any evidence?
Yes, Your Honor. State offers State's Exhibit 1 and all attachments.
Without objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand?
Yes.
By entering this plea, that means that the state will not be calling any witnesses. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. The court has reviewed the same. Court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We simply ask that the court honor the plea of Your Honor.
All right. Then the court, as previously stated, is finding you guilty. The court will follow your agreement, sentence you to 138 days in the Bexar County Jail under 1244. Give you credit for any time served. There's $1,000 fine. Time and money will run concurrently. Did you review the trial court certification of defendant's rights to appeal with your attorney?
Yes.
Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. So it appears that you may have a drug problem. When you're released from custody, if I'm still here and you are trying to find a place to help you maintain your sobriety, you can come back here. I'll pick up the phone and call somebody to help you. Because only one or two things are going to end up happening. I'm sure your attorney will tell you this. Either you're going to be in and out of somebody's jail or prison, or either somebody's going to be identifying your body, because the last time you use may be the last time you use. You understand?
Yes.
All right, good luck to you. Thank you. Is there anyone else? No, that hasn't been taken care of.
Your Honor, may I approach?
Yes.
Signature. Thank you.
All right, we'll wait for them to sort stuff out. Let's go back to Judge McNally, see what's going on there.
9663.
Good morning, Judge. John Rossi.
Good morning.
We've raised P number 487. Today's the date set for sentencing, Judge, and we're asking for the adoption of the recommendation. I do want to mention.
Let me ask him first. Your name, sir?
Drew Grayson.
All right. So is everything in the report accurate?
Yes, Your Honor.
I'm asking
Yes, it is, Judge.
no material additions, corrections, or deletions.
That is correct.
The agreement was that it be taken under section 7694A, right?
That is correct, Judge.
You've got multiple warrants out.
Well, those are going to be cleared. There, several line items underlined, and he's indicated that he will be very aggressively taking care of that, Judge.
Judge, the victim's on Zoom also.
Good. Where is, can you state your name, ma'am?
John A. Washington.
Okay, I need you to start your video, okay?
Yes.
Okay. And let's just slow down a little bit here. I just want to check. They also notified Braylon Grayson, and you are the mother of Braylon, correct?
Yes.
All right. So now, everything in the report's accurate, correct?
That's correct.
What else would you like to say?
Judge, at this time, there's two items. One involves getting the tether off of Mr. Grayson. He served 11 days as a result of this incident. And also, I just want to make sure that we're all on the same page because it appears that she's, filed divorce and mediation, I believe, is scheduled sometime in November, correct? And I just want to make sure that everything's going to be good with the kids and that there's no contact, direct or indirect. And it appears that a god sister is being used by Mr. Grayson's wife. Is that?
What'd you say?
A god sister of Mr. Grayson's wife is being utilized as a go-between for the children, so as not to violate the terms and conditions of this order, and also one currently in the domestic division of Wayne Circuit Court, or I should say the family division.
I don't see where Judge Kirsten filled out a bond sheet, did he? I don't see what the bond conditions are.
They were originally no contact. One of the major conditions.
Did he write it on the ROA? Sometimes he writes it up in the right-hand corner.
He didn't.
There was a $400, not cash bond, but $400 were paid by Mr. Grayson, got him out after the 11 days that he served in jail. And again, I just want to make sure that we're all on the same page regarding the transportation and visitation of the children, and obviously getting the tether off of Mr. Grayson.
All right, let me just.
Understood, Judge.
Do you want to have, Ms. L, are you on this case? Do you want to state your appearance?
Yes, Noor Alawi on behalf of the people.
Do you want to say anything here?
As regarding to the report?
No, just anything. Do you want to say anything about the sentence? I don't know. You popped your head in. I was just wondering if you wanted to say anything.
I do not have anything. I would just recommend the terms and conditions that I had written on the form there. I haven't been able to speak to the victim today. I'm not sure if she wanted to make a statement.
Ms. Washington, would you care to make a statement?
I went back and forth about whether I wanted to, Judge. At this time, I think that I'm just ready to start the healing process overall. We've already filed a divorce and we're going through with that. This is kind of like one step and then the divorce is the final. At this point, I just want to move on, and other than us having to co-parent as far as our kids and dealing with a third party to do that, that's all I ask. I just don't want any more contact or anything else with him other than just us raising and co-parenting our kids.
Agreed, Judge.
How do you guys want me to set this up? I can just do a no contact except to effectuate visitation with the minor child. In other words, if you could still talk to him and text him or email him, when are you going to pick the kids up? When am I going to pick that type of thing? Or do you want me to do something else, Ms. Washington?
That's other than us just discussing the visitation with the kids and when he's going to see them. That's the only thing that I care to have conversation about with him. Other than that, we don't have anything else to talk about, Your Honor.
And Your Honor, I think that would be appropriate for now, especially given the fact that she said that the divorce process has just started. I assume if it has just started, that the family court will probably implement some form of other form of communication. So I think that would be appropriate for now.
We agree with Mrs. Washington and the prosecutors. Thank you.
All right, sir, I haven't asked you if you want to say anything. Would you like to say anything?
Just ready for the process, just ready to move forward, Your Honor.
12 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance if you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. You're not to have any contact with the victim, Joan A. Washington, except to effectuate visitation with the minor children. No contact except to effectuate visitation with the minor children, sir. You're not to possess firearms. You're not to possess dangerous weapons. I am taking this under the provisions of section 769.4A. You're to obtain and maintain employment and provide proof. Again, no contact with Janae Washington except to effectuate visitation, no firearms, no dangerous weapons, obtain and maintain employment, clear all of your outstanding warrants to the extent that you haven't. Clear all outstanding warrants by October the 15th, no later.
Judge, is it possible to make it November 15th? He's currently in the process of looking for another job. He's been doing some side jobs in order to make ends meet. He is living with his grandmother, and this has been a process over, I believe, several years. Am I correct?
He's only, I thought you said he had taken care of anyway.
He had, there were up way more than this, Judge. I don't know how it.
I'll give you until October 30th.
Judge, thank you so much.
Okay. No firearms, no dangerous weapons. You said he's got, he had 11 days. I'm not counting 11. I'm counting 18th, 19th, 20th. There should be 9. There should be 9 days.
Okay,
credit.
Judge, I'm sorry.
That's all right. So 9 days jail, credit 9. I'm not going to make you do the court work program. Okay, so I'm taking under 7694A, $100 fines. Oh, and by the way, you're going to do the domestic violence program with 8-week follow-up, okay? Domestic violence program with 8-week follow-up, fines 100, costs 150, 75 victim's rights fee, $50 justice assessment. So fines and costs here amount to 375. You have a screening fee of 60 for 435. You have probation fees of 240. Your total is 675. You pay that, you stay out of trouble. If you're compliant, the case will be dismissed at the end of the specified period. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand all that?
Yes, sir. So Judge, we're asking for time to pay this.
Okay. Give me a review hearing date first, Lisa. It should be back in, I don't know.
Excuse me, Your
September
Honor.
8th.
I'm sorry. Excuse me, Your Honor. Can I just ask? Did want to ask one other thing. I have sold our home, and he does still have a few things here. Will it have to be? Because I know he's still on the tether as of right now. But they
We're gonna
Go ahead.
We're gonna take the tether off. So Lisa, send that down, please, to the county and tell them we're taking the tether off. You can return your tether. And so you want him to be able to come there once to get his personal belongings?
Yes, and the pet, because I have to sell the home and he cannot come with me, and I don't have a vehicle. He took his vehicle back. So if he can just take his things as well as the animal with him today, so that the contractors who bought the home could start coming in.
Defendant to make arrangements to obtain personal belongings. And the address again, we're talking about?
19646 Homestead Lane.
At 19646 Homestead, Gibraltar, accompanied by the police. So you have to, you're to make arrangements to obtain your personal belongings, but must be accompanied by the police. Do you understand that? So you're gonna have to get a hold of Gibraltar Police Department, and they're gonna tell you when you can go over there. They'll stand by, but you gotta move the stuff out of there quickly, okay?
So. And again, does that include the dog? Because there was an issue of an animal.
I'm not getting into the middle.
Understood, Judge, understood. There's nothing to deal with here. Okay, thank you so much.
You guys, wait 1 second. You don't really want, do you guys have a dispute over the dog?
There is no dispute, Judge. It appears that Ms. Washington wants Mr. Grayson to take the dog, and I just want to make sure again, we're all.
That's fine. Just make sure it's properly licensed and everything else is carried out. I'm gonna let you pay this at the rate of $50 per week, and I'm gonna start this beginning on October the 17th, okay? We'll make it the 20th,
Judge, thank you.
okay? If you need more time at any point, if you don't have the money, no problem. You call the court, we'll go on Zoom, or you can walk in here on or before the due date, 8:30. I'll be glad to give you an extension, okay?
Judge, thank you again.
I do wish you well, sir. You'll meet with probation before you leave.
So Lady Jack's just put in the comment, good for her, starting the healing process. Agree? I have a small addendum, though. When she was talking about the children and communicating with him regarding the children, she almost came across to me like the children were a bit of an afterthought in her mind. Like kind of a side project. At least that's how I took it. And if that is the case, I feel very, very sorry for those kids, because it's bad enough that they already have a broken family. If those kids aren't put first, that's going to be really unfortunate and potentially create less than ideal adults when they're grown up. But we'll see what happens. Let's go back to Judge Middleton, another orange contestant.
Oops, sorry.
Good afternoon, sir, or morning, it feels like afternoon. Are you Willard Pelfrey?
Yes, I am, sir.
This is Judge Middleton. I'm here at the court. Your lawyer, Mr. Truckee, Ross Truckee, is here with me. Also, Chief Assistant Prosecuting Attorney Joshua Robert. In this case, you're charged with possession of methamphetamine. Let's actually look at the complaint. I can find it. It's alleged that on September 9th in the city of Sturgis, you did possess methamphetamine. That is a felony. It's punishable by up to 15 years and up to 10 years imprisonment and a fine of up to $15,000. Do you understand?
Yes.
The prosecutors agreed to dismiss that charge for a plea to use of methamphetamine. That's a misdemeanor. To a year in jail and a fine of up to $2,000. You understand?
Yes.
Are you going to plead to that misdemeanor charge?
Yes, I plead guilty.
All right. Anybody threaten you to get you to do that?
No, sir.
I promise you anything?
Nope.
All right. Do you understand that by pleading to that charge, you'll be giving up your right to have a trial in front of a judge or a jury? There will be no trial. Do you understand that?
Yes, sir, I do.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Truckee is here with you. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes.
All right, let's talk about this. Did anybody threaten you to get you to plead to this?
No, sir.
Or promise you anything?
Nope. No, sir.
Now, I know a little bit about this because I arraigned you on the trespass ticket that was out there. But you were walking down the railroad tracks on September 9th, and you had your pack and stuff with you. And they found a small amount of methamphetamine in your possession, which came back as positive for meth. Is that true?
That's true.
And had you used some?
I did prior, maybe a week before that, because I just knew it all this, and it really wasn't what I thought it was going to be. So I thought I was just going to toss it out, but I ended up putting it back in my pocket for some reason. I don't understand why.
All right, well, that's enough for the plea, but I don't believe you. I think that you're struggling with methamphetamine and goes hand in hand with your homelessness. But what you told me is enough to accept the plea. You could have just owned it. You've been in jail for 14 days. Where are you going to go if you get out?
Probably to go to where I was before, Rips, front porch, and get my stuff, go to Elwood, apply for a job, and then come back to go do the program at Keystone here in Centerville. Hopefully get a place here in Centerville.
All right. Mr. Truckee, anything you'd like me to know?
I've encouraged Mr. Pelfrey to use Keystone, see if that can help get him off the streets. He's not gonna be able to get clean if he's living outside.
Yes, and it's gonna get cold. Mr. O'Bear, anything to add?
No.
I'm gonna order 30 days, credit 14. No fine, no attorney fee. Minimum fine of $125 for 2 additional days. You got about 2 weeks of additional clean time, Mr. Pelfrey. And maybe there'll also be some time to work with Pivotal on a placement rather than just to have you standing out on the front steps today with nowhere to go. Do you know what they did with your pack and all your stuff?
Actually, a young lady gave that to me that day to keep for myself. And I really don't know where everything's at. Everything could be gone because a lot of people goes up on his porch and does whatever they like to do. And yes. I'm pretty sure about everything I have is gone.
So basically you got the shirt on your back.
Yes.
Do you have any family around here?
Well, I got family, but they're all they're like on the other side of the tracks. They don't have nothing to do with my side of the family either. My mom, dad, sisters, aunts.
There's a lot of Pelfreys around Sturgis area.
Yeah, but they're not the type of the Pelfreys that would help me do anything. I don't even know half of them. I just met Tim Pelfrey that's in here. I just met him just a year and a half ago. And that's
all right, well, I'm going to give you some clean time. All right, Mr. Pelfrey, best of luck to you.
Thank you.
You're good to go.
Thank you, Your Honor.
All right, let's head back to Judge Boyd. We have a pretty standard rotation going today. Sometimes it just works like that.
I'm doing okay. How are you doing? All right, so why were you late for court today?
Missed the bus.
Okay, so make sure you don't miss the bus, all right? I've ridden the bus before, and I will tell you they have their set times, but for some reason, when I was riding the bus, I don't think they do this now, but when the bus was early, they'll leave you. I mean, it will happen. But I know once you miss one bus, if you have to connect or transfer, it throws the entire schedule off. All right, so where are we on discovery?
Judge, last time we were here, I believe the only issue was the video from the jail, which I believe the state has already acknowledged they do not have.
Yes.
In which case, this was the plea deadline. I discussed the offer with my client. He rejects it and he would like a jury trial.
Okay. State, how long, if you all could sign an acknowledgement of discovery if one has been assigned, and how long do you all expect this trial to be? 3 days. Norma, I need a jury trial date, criminal trial division, 3 days. And thank you for dressing appropriate for court. You always do. December 9th, council.
That'll work, Judge.
All right, so we're gonna bring you back on December 9th. I would bring you back sooner, but we have so many cases that are set for jury trial, okay?
Is it possible to have my ankle monitor removed? I'm working, I start Thursday, I'm in a sober living home.
Okay, let me ask you this. So you're just on partial GPS now?
Yes.
State, do you have any objections? He is actually in a sober living home and he works. Do you have any objection to just tracking?
What is he on for? I don't know what he's charged with.
Oh, it's a drug case. All right, so what we'll do is we'll do tracking only. And counsel, let me see. Just 1 second. Let me find something. That's not what I want. Just give me 1 second, counsel.
And then the signed acknowledgement.
Okay, just give me 1 moment. Let me give this to you.
Yeah. Go to meet that.
It should have been just. Oh, I'm so sorry. I didn't delete this last part of it. Is there any way you can cancel? Oh, it's already done. Oh, thank you. Thank you. All right, I'm going to print one more thing, guys. All right, you're welcome.
That was awesome.
You know, one stop here.
Yes, it is.
So if you'll have them sign off on that, please. And then, sir, once you sign the reset form, you will be excused and the state has agreed to tracking only. So I will sign that order and then it will be tracking only.
Okay, so what is the name of the?
Oh, that means that you're allowed to go wherever you want to go, but it will show where you are. So if there's something where you know you should not be and you're there, that will be an issue. And counsel, if you want them in back to print you a copy of that, and they also need to file stamp it. All right, and you are excused once you sign the reset form.
Judge, we've done that and I'll go back to,
All right, thank you, but make sure they file stamp it.
I will check.
Thank you. All right, who's ready? Vincent Gonzalez. Mr. Gonzalez, where is he? All right, Norma. Their client is not here. He hasn't been brought over.
There's not enough upstairs for ad sale.
Okay. All right, yeah, just wait just a moment, okay?
That's what I was gonna, I've got the same issue.
Who do you have?
Being honest, I was gonna ask for the phone for tomorrow. So his indicted case was gonna get dismissed, but they just indicted the new case. So I was gonna confer and see if he wanted to take a plea on his case.
So here's my question. Can they be done by Zoom? Are they here at the courthouse? They're just not. Yes, let's zoom them in. All right, so zoom them in, Norma. So we will zoom your client in.
Okay.
All right.
Trey's gonna do my plea for me on my
Okay.
other case.
Yes.
And I haven't conferred with this guy on the offer yet.
Okay.
But I'm gonna let Trey do it so I can run them.
Sure. Ms. Kogut, they're gonna have your client by Zoom. I thought he was at the courthouse, but he's still at the jail. So we'll have him zoom in, okay? All right. Anyone else ready? Hello, Dorio Willers.
Here you are.
Thank you. All right, thank you. And is this a plea just to one of the cases?
Yes, Your Honor. The state's declaring their dismissal on the other charge.
All right, the court is calling 2025 CR 002159, State versus Helidorio Willers. Can I have the parties announced?
Megan Galloway for the state.
Justin Fox for defense.
And are you Mr. Willers?
ma'am.
And there are no applications?
No judge.
No, Your Honor.
Counsel, you received all discovery. Did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Mr. Willers, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are waiving the repeater enhancement.
Any objection?
No, Your Honor.
Mr. Willers, did you review the court admonishments with your attorney? Did you understand it and did you sign it
Yes, sir.
in all the appropriate places? You're charged with assault on a peace officer or judge as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Willers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering into this plea bargain agreement, you will be deported, denied naturalization, and not allowed re-entry into the United States. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $2,000 fine and there are no applications. Did you understand that to be the plea?
Sure.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and did you sign it in both places?
Yes, sir.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
State offers states one in attachments.
No objection, Your Honor.
All right, I'm sorry. Was your plea guilty?
Yes.
Okay. All right, any objection?
No, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it?
Yes.
All right, off the record for a moment.
Yes.
All right, thank you. All right, we're back on the record. All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, the state would not be presenting any witnesses and they would be proceeding on police reports?
Yes, Your Honor.
All right. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, well, we spoke yesterday, Your Honor. We could reschedule for sentencing in 2 weeks.
All right. So, Ms. Ferguson, if you can recall this in 2 weeks, please, for sentencing. And there's no PSI.
No, Your Honor, that's correct.
All right, October 7th. And I'm sorry, counsel, can I have the trial court certification back, please? All right, so we're going to come back on October 7th. At that time, I will enter the sentence, okay? All right, thank you.
Thank you, Judge.
And I'll keep that with this.
Thank you.
Does anybody have a rubber band?
I have several, Judge, but I don't think I can get them to you in the time frame you're looking for. Let's go to Louisiana. We'll try one more of those.
The time is 9:19, and we are at Bossier Parish Maximum Security Facility. My name is Carolyn Stapleton. I'll be chairing the panel today. My colleagues are remote on Zoom, and they're Ms. Jerry Ledoux and Mr. Steve Freeman. The panel is at headquarters today, where I'm at, and headquarters staff, will you please? No, we only do that first. Okay. All right. So let's see, Mr. Guthrie, will you please introduce yourself and with your DOC number for the record, please? Oh, you're on mute, sir.
Norman Guthrie, 384459.
Okay, is there staff in the room with you? Is there anybody else in there?
No, ma'am, I'm alone.
Okay. All right, so, your revocation is gonna be handled by me today. So I'm gonna read out your rule violations. Number 2, you failed to report to your parole officer for the months of March, April, June, August, September, October, November, December of 2024, January, February, March, April, and May of 2025. How do you plead? Guilty, guilty with a statement, or not guilty?
Not guilty.
Okay, and is that gonna be with a statement later?
Yes, ma'am.
Okay. Okay. All right, rule violation number 3. On May 2024, you provided your supervising officer with an address at 1120 Crestwell. However, you were not residing there. You failed to gain permission prior to make any change in your address. Guilty, not guilty, or guilty with a statement?
Not guilty with a statement.
Okay. You committed the offense of theft of a motor vehicle fuel, which is a misdemeanor, for which you were arrested by the Bossier Parish Sheriff's Office on or about 3/30/2024 or 5/6/2024. You pled guilty to the theft under $300 in Bossier, number 251095, and was sentenced to time served. That's correct?
That is correct, but that charge, it was before I was even on parole. It was things from, yes.
Okay. I'll write that down.
Yes.
Okay, you failed to obtain employment or provide any proof of attempting to do so. That's rule violation number 6.
I'm disabled.
So do you get, so are you guilty or not guilty?
Not guilty.
Okay. Okay, and, number 9, rule violation number 9, resident visits were made impossible as you absconded supervision, making your whereabouts unknown.
Not guilty.
Okay. And you failed to pay supervision fees as instructed and you are currently $1,890 in arrears.
Not guilty.
Okay. All right. So I'm going to read here what was found concerning those preliminary hearing and the reason that you were brought in.
Yes, ma'am.
It is the finding of the hearing officer that probable cause does exist to believe that Norman Guthrie violated the conditions of supervision based upon the testimony of his current parole officer and statements made by Mr. Norman. On probation condition number 2, probable cause was found. Even allowing time in Arkansas, he still did not report to his parole officer since August of 2024. Condition number 3, probable cause was found. Norman admitted to not reporting to his parole officers or his whereabouts, and then said he was sending text messages and emails, but admitted he never had gotten any reply. He also admitted to reporting to the district office to fill out the change of address. On condition number 4, probable cause was found, and he was found guilty to the charge and sentenced to fine with jail time. On condition number 6, probable cause was found. Norman admitted to not looking for employment, stated he was disabled, but also admitted to having been denied twice for SSI benefits. On condition number 9, probable cause was found. He failed to report to Shreveport District Office and submit his monthly supervision report of his whereabouts. On condition number 9, probable cause was found. While Norman wants to claim he was on inactive status, no request was ever submitted. His prior approved residence is a sober living house. He admits to staying on it for one day then 1 day at the Christian Development Center, and then 10 days at the Salvation Army. He admitted to not notifying his parole officer of his whereabouts, and a warrant was issued on November 19th, 2024. On condition number 10, probable cause was found. He admitted to not paying his supervision fees. Hearing was concluded. Mr. Guthrie will be held without bond pending the decision of this parole board. So you heard the decision of the preliminary hearing.
Yes, I didn't understand that that was a preliminary hearing. That was just me and my parole officer talking.
Well,
But I understand. I understand now. Yes.
you did have a preliminary hearing, correct?
No, I had no idea I've ever had a preliminary hearing. I was talking to my parole officer, and there was another woman in there. Nobody told me that that was a preliminary hearing.
So everything that I just said was true?
And absolutely not, not even remotely close.
So tell me your truth.
Okay, I have a copy of the violations that you wrote to me. Have read off to me. Right here, as you'll go to condition number 2, where it says I will the whole year of 2024. Okay, first off, skip down to condition number 4, where you'll see where I was incarcerated in Bossier for the March, April, and June. But up in condition number 2, they're saying that I didn't report for the whole year of 2004. Let me run through the whole year of 2024, where I can tell you, first off, for the record, I have never missed a report whatsoever. We are in an electronic age. Through my chief parole officer was Officer David Kerr. Me and him had a great rapport. And I reported with him mainly electronic, either through Google Meet, text message, or over the phone. Very few times was I asked to go in to do a monthly report. So let's make that perfectly clear. So for the whole year of 2024, over 9 months of that, I was incarcerated for charges that stemmed before I was released on parole in the state of Louisiana. I was on parole in the state of Arkansas until the end of 2024. In Louisville, Arkansas, I had a 15 years charge for a second-degree battery. I got released in 2011. In 2019, I caught these charges here in Bossier Parish, but I was on parole till 2024. When I got released in 2022, my parole officer and the parole officer in Arkansas did not collaborate together, so I was doing 2 parole sentences simultaneously. And
let's go back to, you were sentenced in Arkansas for this crime.
Yes, ma'am. In 2007.
Huh?
In 2007.
Well, what does that have to do with 2024 then?
I was still on parole when I got out. All right. So unbeknownst to me, my parole were not ran together. So I got incarcerated, and I was in CCC, and I was in Bossier Max, and I was extradited from Bossier Max back to Arkansas for all of these months that they're saying that I didn't report for the 2024. It's blatantly a lie, and I have proof. Yes, I was incarcerated for 9 months of the 2024. When I got released, someone from a sober living house in Shreveport, Louisiana, drove down to Arkansas and picked me up from the Arkansas jail and brought me in. I came to a sober living house. His name was Lee Hartman, and the sober living house was One Way Ministries. He drove and picked me because I had no one to pick me up. Now, I did not have a parole hold on me for the state of Louisiana. I came to this sober living house, and that was in, let me see here, March, April, and June. All right. I was incarcerated here in Bossier Max for the theft of motor vehicle fuel, which what it was a State Farm insurance. I called State Farm Insurance roadside assistance, and someone brought me some fuel. There was a mix up, and they charged me for theft of motor vehicle fuel because I didn't pay for the roadside assistance. Anyway, that stemmed before I was even released on parole in the state of Louisiana. Okay, so you can see that they saying that I didn't report for those months. I was incarcerated. In July, I went to Webster Parish for a 2017 ticket. From there, I was released to Cresswell Avenue, which was Mr. Keith Slaybaugh. He's the pastor here. I was released to his habit. From September, October, November, and December, I reported to Mr. Kerr, and he put me a recommendation for inactive status.
Okay, listen, let's just time out on that. Okay,
Yes,
I'm gonna go back to the theft. Okay, and it said that you pled guilty to theft under $300 in Bossier. And you
That
were
is correct.
sentenced to time served. Are they lying now about that?
Absolutely not. But I pled guilty, but this charges stem before.
Okay, so we got one you pled guilty to. Okay, right?
I'm not pleading guilty to the charge that I caught this charge while I was on probation. I mean, on parole. I did not. This
Well,
charge seems from 2017.
I'm not gonna go any further with this. This is just round robin, really. All right, so it's got here that you pled guilty to theft under $300, Bossier City, and number 251095, and you were sentenced to time served, and that's number 4. You committed the offense of theft of motor vehicle fuel. You're saying, the insurance company brought it to you, and somehow or another you got charged with that. I don't know. I don't see how that's even possible. But you did plead guilty, so you're saying today you're not guilty, but you pled guilty and you got sentenced to it.
It has absolutely nothing to do with my parole. It was before I was even put
Has
on.
everything to do with your parole, because you're not supposed to break the law while you're on parole.
I wasn't on parole in the state of Louisiana, Mel. When this charge was arrested, I had a detainer on me for years. I've been incarcerated. When I got out, my parole officer didn't know about it, and so I got arrested. And when I pled
guilty to executive session. Do I have a second? Okay, we're going to go into executive session to discuss confidential matters, and the time is 9:32.
Yes, because I didn't get arrested for this charge while I was on parole.
Yes.
You gonna do?
Yes.
Yes.
Thank you. Yes.
Okay, so while they executive session this, so I think I know what his disability is. So it's little known, but there is a gland on the side of your brain that is your law-abiding gland. And my guess is that either that gland is not performing properly, or perhaps it was removed in a botched lobotomy, something like that, that's causing him to commit these crimes. It's kind of sad, I suppose, if you think about it. I mean, this poor guy, he's got a disability, and so he can't do what he's supposed to do, but he can certainly do all the things he's not supposed to do. So maybe we should just all be more compassionate and more understanding of this poor guy with his disabilities that are clearly affecting him and everybody around him too. All those who have been victims of his crimes, all of the taxpayer dollars that have gone to house him and feed him and clothe him and get him through the legal system. Yeah, all because of his disability. It's sad. It's very, very sad. Double super sad. All right, we're in the way back machine, so I'm going to move us forward. Oh my goodness, they were in executive session forever. All right, let's go right about there. Okay.
And that concludes this hearing, at,
No, it doesn't, because I don't know what happened. All right, hang tight. This will sneak up on it. They come out of executive session, it looks like, for about 30 whole seconds. But this will be the last thing that we do for today because we are into overtime here just a little bit. So let's get this, and then we will all move on with our day. Come on. Come on. You can do it. There we go.
okay, the board is back in session and the time is 9:52. We're going to continue this hearing at a later date because we're going to send it back to the officer, the report back to the officer for the clarification. And that concludes this hearing at Bossier Maximum.
Miss Carolyn, excuse me.
I'm sorry. Yes, yes.
Madam Chairman, do we need a vote on that?
Do we?
You vote to continue, you need.
Okay, I'm voting to continue, and yes, we do need to vote. I'm sorry.
Okay,
Mr.
that's I concur. Vote to continue.
My vote is also to continue this case for clarification.
How long will it be continued?
I don't know. You will be notified. And we're logging out at Bossier, and the time is 9:53.
So here's my take on that. The only way that I could justify this being continued, based on what we've seen, now obviously they probably have information that we don't, but based on what I've seen, the only way I can see this being continued and being a good thing is if it's continued for maybe, say, 15 years. Did this guy somehow talk himself into them having doubts? I'm so perplexed. I'm so confused and amazed. And I mean, dude had every excuse in the book. And this board, who is known for denying everybody, is all of a sudden like, maybe we need to take a time out. Again, benefit of the doubt. They have information we don't. We're just watching from the outside. So, yeah. We'll just leave it at that. Michael says, I really need to make a WTF stinger. Yes, you might have to make that for me, Michael. That would be great. Thank you. So we end the day on a cliffhanger, my friends, because we do need to go. We're a few minutes into overtime, and I have like 5 hours of errands I have to run between the two shows today. Speaking of which, tonight, sidebar, 8 p.m. Eastern, 5 p.m. Pacific, we're going to talk about celebrity justice. This is a Michael idea, so it should be fun. And Lindsay will be joining us on the panel, so be sure to tune in. 8 p.m. Eastern, 5 p.m. Pacific. It is already posted on the channel, so once you exit here, just go to the channel page. You'll see it. Click on the Notify Me button so you're sure to see it, because YouTube has been real weird with their notification pushes lately. So even if you're signed up for alerts, go click on the Notify Me button just to make sure. So join us for that tonight, and we'll be back tomorrow morning, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. I appreciate all of you. This was fun today. I hope you enjoyed, and I look forward to seeing you tonight and tomorrow morning. Take care. God bless.